This is LXBN TV, and I'm Colin O'Keefe. A New York attorney attempted to recover millions of dollars from his wife after their divorce settlement because part of what he gave her was from a fund invested with Bernie Madoff. To explain the story, we bring in New York attorney Neil Cahn, author of Divorce, New York. Neil, first off, can you give us the backstory here? What exactly happened?
Standard story. Parties went through a divorce, ultimately settled, and made certain trade-offs and discussed generally, you take this asset, I'll take this asset, and entered into a written agreement that reflected that division of assets, and that stipulation was incorporated into the divorce decree. 2 years later, 2.5 to 3 years later, one of the assets that the husband decided to keep, the Madoff account, was determined to be, at that particular time, worthless. He had given his wife a certain amount of money to offset the fact that he was keeping the Madoff account. He wanted to undo the deal because he believed the deal was no longer equitable. And had he known the true story, that the Madoff account was a Ponzi scheme, the assets would have been divided differently.
And, you know, he's asking for, of course, court-ordered relief in this case. But oftentimes, I think you wrote about this, court-ordered relief in cases like this is often reserved for quote, exceptional situations. Why isn't this case considered an exceptional situation?
Well, certainly it is a routine situation taken to the extreme. It is not uncommon for assets, unless they are divided 50-50 in kind, for one asset to go up in value, another asset to go down in value, particularly over the last several years. If parties were dividing different stock accounts, the stock market has gone up and down. Real estate markets have gone up and down. So changes in value of assets that are divided is not an unusual phenomenon. Certainly what happened here is taking that to the extreme. But what the court is really looking to do when it reforms agreements or correct mistakes is to take a situation where there's a mathematical error, where there's an impossibility of performance. Say, for example, they decide to divide up a parcel of land, and then it proves that the parcel can't be divided. The court will come in, reform the agreement to correct the situation that the parties obviously intended to deal with. Here, the husband made a choice. He made a choice to keep the investment account with Madoff. He gave the wife different assets, or the wife agreed to accept different assets. The husband made a business decision, and the wife made a business decision. The court was not going to step in 3 years later to correct the situation where they could have handled it differently.
And the way I've seen many people describe it is if this account hypothetically were to be worth much, much more, he wouldn't be paying her money now if that were the case. And then finally, you wrote that another problem with this is that in the original divorce settlement, or the divorce agreement, the couple didn't show their work. What do you mean by that? And then, what advice would you give for divorcing couples on how to do that?
Okay. The Court of Appeals noted two extraordinary facts or routine facts that justified or upon which they based their decision. The first fact was that the parties did not list all their assets, say we are going to divide these 10 assets on a 50-50 basis, and therefore you can't go in later and say there was a mistake in valuing this total group of 10 assets. Instead, there were lots of different waivers that were exchanged, waivers of maintenance, waivers of other equitable issues. So there's no simple formula. More importantly than that, this account was not worthless the day they made their decision. The court noted that, in fact, the husband went to this account to draw out monies which he used to pay off his wife. It only became perhaps worthless, and it'll be ultimately issued up to the bankruptcy courts and other securities forums to decide how much money, if anything, he gets back. But the account was not worthless at the time. It was a continuing business investment decision by the husband to keep it there. What every practitioner, every party should try and do is look at their agreement and as far as they can, to every sentence, to every phrase, ask, what if? What if something proves worthless? What if something is delayed? What if this expected event does not take place? And if you can ask the what if questions, like a two-year-old would ask, why, you will be able to provide the court with an understanding of exactly what was in the minds of the parties at the time, what they contemplated, and what they agreed should be done if something goes wrong. The more work that you can show within your agreement, the greater care to describe exactly what the parties wanted to do, the easier it will be for the court to provide relief later.
Mm-hmm. Absolutely, absolutely. This is a very interesting case, but one, though the circumstances are unusual, the happenings not necessarily are. I mean, this happens where assets drastically reduce in value, especially over the past few years. So it's an interesting one to watch, but when you look at the facts of the case, not entirely unexpected.
Absolutely, Colin.
Once again, that was Neil Cahn of Divorce New York. For more on this story, be sure to check out his blog. It's at divorceny.com. And of course, we have a few other posts on the story as well at lxbn.lexblog.com. Thanks, Neil.
Thank you, Colin.